Thanks again, everyone, for being patient with us while we get it all up and running. And today we are hosting Miss Conswella Byrd. Conswella has been an estate planning attorney since 1990. Her law practice focuses on estate planning, wills, trust, and powers of attorney. She's also taught wills and trusts as a law professor. Ms. Byrd has a dual background in nursing and law. She received a bachelor's degree in history from the University of Illinois at Chicago. Big time, big time. She's also a registered nurse licensed in California with a Bachelor of Science in Nursing from University of California at San Francisco. Ms. Byrd is admitted to the following bars: the State Bar of California, the U.S. District Court Bar, the U.S. Court of Appeals for the Ninth Circuit Bar, and the United States Supreme Court Bar. Amazing. She's a member of the State Bar of California Estate Planning, Trust, and Probate sections, the East Bay Trust and Estate Lawyers, and the American Association of Nurse Attorneys. Who knew there were nurse attorneys? So I want to welcome Conswella today. Thank you so much for joining us. It's a pleasure.
And thank you for inviting me.
So today I told everyone we were going to talk about wills and living trust and just giving them an idea of what they should have and how to start the process. It's something that none of us likes to talk about or deal with, but in my profession, I see a lot of people that have problems with real estate related and other issues as well, because they don't have a will and let alone a living trust. So I'm wondering if you could just tell us what estate planning is and who needs it.
Okay. Well, estate planning is an area of law which includes documents and procedures that govern two major life events for people. One is death, and the second is incapacity. So in this area of law, it governs who will get your property upon your death and other matters that will occur upon your death. But also a second area that's certain to some of us, but not to all of us, and that's incapacity, when you're mentally not able to make decisions for yourself. So in this area of law, there includes a lot of documents and procedures. Living trust is one of them, a will is another one, durable powers of attorney is another one, advanced healthcare directives, a whole slew of other documents that are included here.
So what happens if you don't have a will or a trust? And I know you're going to take us through some of the procedures or steps we should take to get it together. But if we could look at the big picture down the road without having anything, what might happen?
Okay, well, essentially everyone has an estate plan. The choice is whether it's the one for the state of California or the one that you make for yourself. So it's that important in life that everyone has to have an estate plan. So the one for the state of California has for everyone is the default one. If you don't do anything for yourself, then you'll go by the plan that the state of California has for you. And it does not mean that the state of California is going to take your property. No, it just decides, one, who is going to get your property upon your death, and that's based on your close relationships of blood and marriage. And secondly, the second major life event of incapacity, it decides who will make those decisions for you when you're not mentally competent to make those decisions for yourself. Now, if you have already made your own estate plan, then you don't use the default one from the state of California. So in making your own estate plan, you have to cover those two areas. One is who will get your property upon your death, who will take care of your minor children for you when you have passed on. And the second major life event is incapacity, who will make financial decisions for you when you're not able to do so for yourself, and who will make healthcare decisions for you when you're not able to do so for yourself. How am I doing?
You're doing great. They're uncomfortable questions. I know for me, and no one wants to think about, being disabled or incapacitated or not being here at all. So it's a tough subject. And not only that, I don't know that I really knew who to go to. It's not like I know any estate attorneys. Now I know you, but I mean, just
Yes,
in the
you know
course of
one.
life. Yeah, I do. In the course of life, it seems like, from my perspective, especially for African American and Black people, we don't have attorneys, we don't have CPAs, we don't have financial planners, and we have to do better. So some of that goes by the wayside. What would be the first step in dealing, or do you recommend in dealing with, say, just if you start with a will? Or do you do both, or is a will incorporated into a trust? And then I'm going to stop asking questions.
Well, you don't ever have to stop asking me questions. But here's the thing. So you have to look at what are your goals for your estate plan? What are you trying to achieve here? One basic thing that most people in our state are trying to achieve is avoid probate on their property when they pass on. Our probate fees start at the gross value of the estate of $150,000. So in our state, if you own any type of real estate, you are above that limit and you're going straight into probate. And probate can be just a basic fee, about 10% of the value of the estate, just roughly. It might be a little bit more, it might be less. And that's money that could have gone to your beneficiaries, but it's going to the state. Now, it's not a bad thing, at least my personal opinion is not bad, because it's providing a service that is crucial to our whole flow of society. But everyone has a choice. You can make your own estate plan, or you can use the one in the state of California. If you use the state of California, you have to pay fees, and that's going to be the probate fee. Now,
And that's about 10%, or could be a little less, or could be a little more.
Right. It depends on what that whole basic is. And also, if there's any type of fighting or will contest or probate contest, then it's going to be more. So it just depends.
I see.
And then, of course, if you're still alive, you haven't died yet, but you're incapacitated, you can't make decisions for yourself, then someone has to step in to make those decisions for you. If you haven't done it through a power of attorney or advanced healthcare directive, then your relatives, your friends will have to go to court to get a conservatorship placed on you. And that's another court proceeding that's going to cost money that goes to the court in our probate system, where the court will appoint someone among your friends and relatives who the court decides would be the best person to make those decisions for you. Now, you could have avoided that if you had done made as healthcare directive and durable power of attorney, but if you don't do that, it has to be done. These are things that are just basic. They have to be done. So either you do them or the state of California does it.
So if you had a house, for example, oh, did I do that? A house, for example, that you own free and clear, the house is worth, we're not quoting anything here. We're just giving examples. If the house has equity of like $300,000, okay, 10% of $300,000 is about $30,000. That's about that. That's just on the value of the property. Is that correct?
Well, we're looking at the gross value of the estate.
Okay,
so it's not necessarily the equity, it's the gross value. So it'd be the gross value of that property, which could be a lot more than that.
It will be a lot more than that. In Oakland, we don't have any homes for $300,000.
Exactly. That's why I said, no, it's going to be more than that. It's the gross value.
Oh, painful.
Yes, yes. Now you see how serious this is.
Yeah. So one of the things I think about, I was a single parent, and I was never thinking of a living trust, but I was more thinking about the will, because I was concerned about, so what's going to happen if something happens to me with my daughter, my adorable, lovely daughter? What's going to happen? And so I was more focused on a will. Is there something that we should prioritize in terms of if we don't have the money? And I never had extra money to do a trust, and I heard all kinds of rumors about it back in the day. It was thousands and thousands of dollars, and I didn't have that. So if we don't have that, should we focus on maybe getting a will done, or a will done? And do you have any suggestions on how to prioritize this, or is it on a consultation basis mainly?
Well, I do prefer a consultation basis because then I can look at the entire picture. But just to basically answer your question, it would depend on what the client's priority is. Now, in the situation that you presented, you're saying that you have a minor child and your focus is on that. Now, you would have some real property, but you're not worried about that. Your main focus is on the child. Well, you need to set up a guardianship for that child so you can nominate someone to be the guardian when you passed on and the other parent has passed on. So both parents have passed on, then who would take care of the child? That's done in a will, not in a trust. So you would have to have that guardianship provision in a will that says who that is. Now the parent nominates, the court appoints. So it still has to go through the probate court because the court has to oversee that person, has to approve that person to be the guardian of that minor child, and has to stay involved until that child becomes 18 in our state in which they're no longer a minor. So that would take care of that main priority. Now, the part with the house, you say you have a house, but you don't have enough money to pay an estate planning attorney, various ways you have to figure out what the fee is, but if you just don't want to do it, you could use a joint tenancy if you wanted to do that with another person, not with the child because a minor can't be in a joint tenancy. That would be just a stopgap measure because you would only avoid probate on the first death, but not on the second death. So you would still probably end up in probate.
Right.
Did I answer your question?
I think it does. It gives you an idea of what you need to do. So if you do a will, let's keep it a little separate from the living trust. If you do a will, does the will incorporate the different parts of saying, like you were saying, if you're incapacitated, do you nominate someone in the will?
No, that has to be separate in our state. The will only takes effect upon death. So if you're incapacitated, you're still alive. You're not dead yet. Okay, so a will's not going to help you for incapacity. You need a durable power of attorney or an advanced healthcare directive. And you probably need both. I would suggest both because the advanced healthcare directive is only for those healthcare decisions. And the durable power of attorney is for all the other matters.
Okay.
Okay, so there are 4 major documents that you would need in any estate plan. And you might need more, but there are 4 basic ones. And one is that will that we've been talking about. Okay. And a living trust, and there's a special will that goes with the living trust. There are many types of will. There's a special will that goes with the trust. The trust is important because you can avoid probate, because you're going to retitle the assets and your name is trustee of your trust. And that way it avoids probate because we only probate what's entitled solely in the person's name. With me so far?
I think so. So you had 4 things.
4, okay. So we have the will that we talked about the trust. Then you need a durable power of attorney for management of property and personal affairs. And that means you're still alive, but mentally you're not able to make any of those financial decisions for yourself, such as paying your PG&E bill, dealing with healthcare insurance, dealing with Social Security, disability benefits, a whole plethora of things. So that document will allow someone to avoid a conservatorship, avoid going to the court and get someone appointed as a conservator. And so you nominate the person. You say, I want this person. I'm giving my power to this person. And that only takes effect upon your incapacity as proven by a written statement from 2 physicians attached to that document. So until that time, it doesn't come to life at all. Then the 4th one is the advanced healthcare directive. And in our state, it has to be separate from the power of attorney, but it's similar in that you nominate someone to make healthcare decisions for you, but only at a time when you're mentally not able to make those decisions for yourself. And you have, they have the written statement from 2 physicians to that effect.
Okay. So we have a question while we're on this. And is this from Dana? What if the child's other parent does not have custodial rights? Could you still grant guardianship to another relative, such as a grandparent? The other person does not have custodial rights.
Okay, that might end up in court. The only thing that you as a parent can do is nominate someone to be the guardian of your minor child. And you can nominate more than one person. You're just nominating. it still has to go to court for approval upon your death.
Okay.
And then it's a hearing. At that time, the court will call that person who you nominated to that hearing and hear from them. But if the other parent is alive, they can come there and contest their guardianship. I'm not saying they're going to win, but they're still alive, so they can have something to say.
Sure. Okay. Okay. Let's see. Do we have any other questions on that? Okay. So, do you have a recommendation on how someone would go about? I know you have to collect the information. You have to decide. Say, if you're a parent, like who you would want to take care of your children, who you would want to handle your financial affairs. Um, can those be different people, or does it have to be one person?
No, those can be different people. And for the most part, they should be different people, because different people have different talents that bring to the table. So one person might be great with the child in terms of taking them to school, giving them oatmeal, all those wonderful things, but may not be good. I don't, maybe people still eat oatmeal. I don't know. Work with me here, okay? But they may not be good with the financial aspect of it. So they would be the guardian of the person, and you would have another person to be guardian of the estate to handle the money for the child. So
that would be a really good idea too, because it can be a conflict, especially depending on the age of the child and the other parents or the other relatives involved. Having different people could cut down on some of that friction, so one person can really focus on the health of the child, and one person could focus on the health of the money.
right, correct.
Yeah, that's a great idea. Do you have any recommendations for people on how to start this process, or what would they put in place first? I think I kind of asked that question, but now I just want to have, do you have a 5-step plan that we talked about, or we didn't talk about, but you discussed that someone might go about? And after we talk about that, then anybody else that has questions can shoot us a message in the chat box.
Okay, this is the 5-step plan that I recommend. And one is I provide an intake form. So I have a questionnaire for people who are interested in hiring me as their estate planning attorney. And it gives me a chance to gather information from them, but they can do it before they meet with me. So they just fill out this form and answer any questions that I have. And they can do this in the privacy of their own home. And so there's no pressure from sitting in my office trying to come up with answers to questions that I'm asking them. So they complete this form, and then they can contact me for a free 1-hour consultation. And I provide that to everybody. Okay. And so they can just come in free, and I even validate parking. So when I say free, I mean free. That's perfect. That's in downtown Oakland, okay? So they come and meet with me, and then we discuss what their priorities are, how they can reach those goals, and what can they do now and how to start. If they decide to go with me, then of course, we talk about my fees and everything that's based on the information that they've given to me in their questionnaire. And so then I would prepare a first draft of the document, send it to them for their review. And they go over that in the privacy of their own home, read through everything. They have any questions, they can ask me, no additional fee. They need to come in and meet with me again face-to-face and go over it, because some of it, is legalese. And I think it's clear, but I'm an attorney, so what do I know? Okay, it's clear to me, but it might be mud to you.
Do you think that on the initial intake, should someone have, if they have kids, should they sit down and talk to the person that they're asking to be the guardian? If they want someone to be their guardian, should they do that first, or should they do that after they sit down with you, or should they be prepared? Who are the people that they want in their life to do this? And should they have a conversation, or should they just write their name in there and not tell them?
Well, I don't think we should surprise them, okay? I think, yes, they should speak with them, but they should speak with the person too who they want to be the executor of the will, who they want to be trustee of the trust, who they want to be in charge of the power of attorneys. They need to have that conversation with them. And then also with dealing with minor children, I just want to add in here, you can set this up, but it's not written in stone. So someone can agree to be the guardian of the child when it's a cute little baby and just precious. But by the time they become a teenager, it's like, oh my goodness. So you can always change it to another person. You know, it's not written in stone, but it's a starting point.
What is that called if you make a change to your will?
It's called a codicil. And if you make a change to a trust, it's called an amendment.
Okay. So you can amend both of them.
Yes. Right.
Both of them. It's not set.
Right. It's not written in stone.
Okay.
Only until you die. Then it becomes stone.
And it becomes
so back to my plan. So
okay.
Then I write the first draft, send it to them for their review. If they're happy with it, we come to an understanding of it. They return it to me. I prepare the final one, and they come in for a signing. So that's step 4. And then 5 is the continual review of their time, because none of these documents are really written in stone until you become either incapacitated or die. And so you still need to review them because your life will change. You know, your kids will start getting older, you'll get older, you'll buy property, sell property, open new bank accounts, and so forth. And so you need to make some adjustments.
So on your intake form, does it tell people? So I have a trust, so I'm a little familiar with some of the documents, lots of documents.
Mm-hmm.
Your bank, if your bank accounts need to go into it, your medical information needs to go into it. Do you have a list of all the stuff that people have to bring to you to include into a will or probably a living trust? I'm not sure if you include that in a will or if it's in a living trust. Do you know what I'm talking about?
I know what you're talking about. All of that is in my intake form because it covers all those different areas and asks you a lot of guiding questions to help you. I also have a lot of brochures, and I've sent you some of them as well, that I send to my clients to help them to be educated about it. I have a lot of information on my website that can educate them as well. And of course, I'm available to answer all their questions because really it's their estate plan, not mine. So I want them to really understand what it is that they're getting and how they can make it work for them.
Well, that feels comfortable to me.
Thank you.
It doesn't feel so scary, shall we?
Thank you.
Can you tell me, can you give us, we didn't talk about this at all, but we have like 3 minutes. Have you ever had a situation that you would like to tell us about? Something unusual that will help people understand an event, going to court or parents contesting, and how to look out for any crazy situation like that? Maybe it doesn't make sense, but it's more about, so when I went through this whole, my parents' estate thing, it made me understand that everybody has different ideas and expectations. And is there a way you can get together with family, or is there anything you can do to prevent chaos when drama and trauma happens in your life, which it's going to happen for all of us? So is it just doing this, or should we be sitting down with people and having conversations?
You have to do both. And this is what I advise my clients to do. You have to discuss this with people. In our society, we tend not to discuss death and incapacity that much, but you need to discuss this with people. So at least they've heard it from you. They know what your wishes are, but you also need to have it in writing so that it's legal. But you have to have the discussion as well so that people can accept it because they've heard you say it and they're following this path of what you want. And that's true with picking out the guardians for your children, picking out the person who's in charge of your will and your trust, your powers of attorney as well. So all these things should be open discussions that we have with people because this is life. Life includes death, life includes incapacity. This is part of life. No one's getting out of this alive, okay? This is going to happen to all of us. So you don't want this to be a surprise to people and say, oh, we didn't know what she wanted. Oh, she picked me. What am I supposed to do? Okay. So I have brochures that you can give to these people to help them understand what their roles are.
Okay. And so we're right on time to end our little webinar, but I do have, we did post Conswella's website information there. And I have some brochures for anybody who wants them. And we're also going to be sending out some additional resources to everyone after this website. And there's a link to Conswella's website where you can set up your consultation. And I think that's about it. Thank you so much. Are there any more questions before we say goodbye and everybody's enjoying this beautiful weather? And thank you so much, Conswella. I really appreciate the information. We all need
Thank you
it.
for having me, Kathleen.
Okay. Goodbye, everyone. Have a good day.